This is an online course for probate conservatorship of the person, which is intended to satisfy the requirements of Probate Code Section 1457 that each prospective conservator have basic information about how the probate conservatorship process works. This is an informational training for conservators and proposed conservators, and is not intended to provide anyone with specific legal advice. As a matter of policy, the courts do not recommend any specific attorney to the public, and in this class are not recommending any attorney in the event you require legal assistance in the future. Any questions that this program is set up to answer will involve general law and/or general policy of the court for all petitioners, and do not give specific legal advice to fit a particular party or situation. This PowerPoint presentation is largely based on the program offered by the Superior Court of California, County of Riverside. This court expresses its appreciation to the Riverside Court, and in particular to Tom Johnson for his assistance in the implementation of this program. This section will give you a brief introduction into conservatorships. A conservatorship is a court proceeding. It is a legal relationship where a judge appoints a responsible person or organization to take care of another adult who cannot care for him or herself or his or her finances. So the responsible person is called a conservator, and the adult being taken care of is called a conservatee. There are three types of conservatorships of the person: a general conservatorship, a limited conservatorship, and an LPS conservatorship. A general conservatorship is set up for adults who cannot care for themselves. These conservatees are often older people with limitations caused by aging, but they can also be younger people who have been seriously impaired because of a car accident, for example. General conservators have significant power to make decisions for the conservatee. A limited conservatorship is set up for adults with developmental disabilities who cannot fully care for themselves, but these adults do not need the higher level of care or help given under a general conservatorship. These are individuals who suffer from a severe and chronic disability that is attributable to a mental or physical impairment. This may include, for example, mental retardation, epilepsy, cerebral palsy, and autism, all that began before the age 18. They also include conditions that are similar to mental retardation or that require similar treatment. For someone with more extensive developmental disabilities, though, the court may decide to set up a general conservatorship. Another way to look at this would be as an extension of duties and responsibilities a parent has to a minor child. In deciding what type of conservatorship is the most appropriate, you should ask yourself if the proposed conservatee needs a higher level of care. In general, a limited conservator has less authority than a general conservator. As a limited conservator, you have the authority to do only those things that were laid out by the judge when you were appointed. The judge has decided which responsibilities the conservatee will keep and which ones you will have. By contrast, a general conservator is empowered to act in areas unless the judge has set limits. This is a general principle that will be discussed later in the presentation. It is important that you understand and grasp that a limited conservatee is considered to be growing and developing. So always try to make choices that will enhance self-reliance and independence. Choices made for a 25-year-old limited conservatee will be different from those made to help an elderly person suffering from dementia. The third type of conservatorship is known as Lanterman Petrus Short, the LPS conservatorships. These are named after the sponsors of this 1969 law in the California legislature. An LPS conservatorship is created to arrange for certain kinds of very restrictive living arrangements and extended mental health treatment for people unable to provide for their own needs, such as food or clothing or shelter as a result of a mental disorder or chronic alcoholism. These persons cannot or will not agree to the arrangement or treatment voluntarily. This online course, though, is not designed to provide specific information as to this type of conservatorship. So if you have any questions, you may want to direct them to the public conservator at 442-265-7000 or the Department of Behavioral Health at 760-482-2132. There are two kinds of probate conservatorship: a conservatorship of the person, which involves meeting the physical and social needs of the conservatee, and a conservatorship of the estate, which involves managing the conservatee's property and finances. There are alternatives to a conservatorship though, so a conservatorship may not always be necessary. A conservatorship may not be needed when the proposed conservatee can plan to meet his or her basic needs, for example by hiring people to come in and cook or clean, or assist with bathing and dressing. In these situations, perhaps this person only needs a little extra help and not a probate conservatorship. Another alternative is planning in advance for incapacity. The court will consider whether the proposed conservatee planned for the possibility of incapacity and whether those plans are sufficient to meet the proposed conservatee's present needs. The most common tools for planning for incapacity are advanced healthcare directives, durable powers of attorney, and trusts. However, only a person who has legal capacity can sign these documents. And these are legal instruments, and these legal instruments may be sufficient to resolve questions regarding medical decisions if the proposed conservatee is unable to express his or her wishes at the time of treatment. In lieu of a conservatorship of the estate, you can be appointed as a representative payee. The Social Security Administration, the Veterans Administration, or participating public or private pension plans can appoint you as a representative payee. As a representative payee, you are the person the beneficiary allows to receive checks in his or her name. The payee controls a bank account into which the income is deposited to make sure that the money is properly spent. If the proposed conservatee is your spouse, by virtue of marriage, the spouse has the right to manage the community property as well as a fiduciary duty to the other spouse, such that a conservatorship may not be necessary if the spouse feels able to handle the situation. If there is a situation where the non-conservatee spouse does not feel able to make a decision, and by non-conservatee spouse I mean the competent spouse, the competent spouse can file a petition to authorize transaction for incompetent spouse. And this is a petition that is filed as needed and filed on a transaction-by-transaction basis. A petition to authorize medical treatment or a petition for healthcare decisions is an alternative if an adult without a conservator needs medical treatment, and this is medical treatment for an existing or continuing condition. These petitions may be filed to determine whether the person lacks capacity to consent to the treatment, and if so, for obtaining authority for a designated person to consent to the treatment on the patient's behalf. This petition can be filed by the patient's spouse, a relative, friend, or other interested person, including the patient's physician. It is important that you know that there are some disadvantages to the conservatorship process. It can be time-consuming and complicated. Depending on your circumstances, it can be a source of stress and conflict, both because of the conservatee's inabilities on a daily basis and also because of opinions family members and other interested persons may have. Also, depending on the case, the procedure can be costly. The court understands this, and so it tries to minimize these potential problems. On the other hand, the conservatorship process also has significant advantages. A conservatorship ensures the safety and well-being of the conservatee. It also offers court supervision, and this is beneficial because obtaining court approval minimizes the likelihood of criticism by others. One of the mandatory forms you will have to review and sign is the form GC 348, Duties of Conservator. There is also a handbook available. This is the handbook for conservators, and this handbook is available at the Judicial Council website at www.courts.ca.gov. There is also a Spanish version available, and this is at www.sucorte.ca.gov. It is important and also required that you read the handbook for conservators. As a conservator, you are the fiduciary, and whether in pro per, which means you do not have an attorney, or if you're represented by an attorney, you are still expected to know the law and your responsibilities. Going back to the Judicial Council Form GC 348, Duties of Conservator, this form provides a list of the responsibilities you have as a conservator of the person. Your responsibilities include assuring the safety and protection of the conservatee, arranging for health care and personal care of the conservatee, and arranging to meet the recreational and emotional needs of the conservatee. As a conservator, there are several things you will need to arrange for and manage. Some things you can do as a conservator are, for example, contact doctors, approve necessary medical treatment, review and determine if a health insurance meets the conservatee's needs, and arrange for family and friends to visit. The conservatee may retain some of his or her rights depending on the type of conservatorship and also depending on the powers the judge gives you. These rights may include, but are not limited to, the right to ask the judge to change conservators or end the conservatorship, as well as the right to be represented by an attorney. As a conservator, you will have the responsibility of deciding where the conservatee lives. You will need to decide on the least restrictive and most appropriate home setting. To do this, choose a place that offers the services allowing the conservatee to live as independently as possible. California law presumes that the conservatee's residence or conservatee's home at the time of appointment is the least restrictive alternative. This is because the conservatee may have more freedom and feel less threatened at home than in any other setting. However, you should always consider whether the conservatee has enough contact with other people and receives enough mental stimulation at home. Wherever the conservatee lives, you are responsible for seeing that the home is safe, comfortable, and will allow the conservatee as much independence as possible. There are different levels of care, and as a conservator, it is your responsibility to become familiar with the different types and levels of care available. Some examples of living arrangements are retirement communities, assisted living centers, and dementia care facilities. It is important to remember that some dementia care facilities are secured perimeter facilities, and these require specific authority before you can place the conservatee in one of these. But this is something we will discuss later in the presentation. Being appointed as a conservator of the person does not mean you control everything regarding the conservatee, especially if the conservatee can voice his or her own wishes. We previously mentioned the Advanced Healthcare Directive and the Healthcare Power of Attorney. It is possible these instruments take precedence over a conservator's decisions. This means these instruments must be observed and respected as they remain in effect despite the creation of a conservatorship. If there is conflict and it is clear these instruments are no longer appropriate, it may be necessary to petition the court to terminate their effectiveness. Now again, being appointed as conservator of the person does not mean you get to control everything. Consequently, you must petition for specific powers. For example, you will need to petition to exclusively make medical decisions, which the court will grant if you can show that the conservatee has lost the ability to make sound medical choices. In the event of dementia, you will need to request additional powers to place the conservatee in a secured perimeter or locked facility, and consent to the administration of psychotropic drugs to treat dementia. If the conservatee objects to a particular treatment, you must petition the court for the authority to arrange for that treatment. The policy in a limited conservatorship is to assist the conservatee in living as full a life as possible by allowing the proposed conservatee to make his or her own choices whenever possible. That is why you will need to petition the court for the power to do things like give or withhold consent for the conservatee to marry, restrict the conservatee's social and sexual contacts, and to make all decisions concerning the conservatee's education. The needs and abilities of limited conservatees varies widely. For example, some are able to perform the basic functions of a day-to-day life, but others are much more limited in their ability to make even the simplest everyday choices. In emergency situations, you as the conservator can give informed consent for medical treatment of the conservatee without court approval, but you need to do so acting in good faith, based on medical advice, and acting in the best interest of the conservatee. Remember, if there is an Advanced Healthcare Directive or Healthcare Power of Attorney, the agent designated by these instruments to make healthcare decisions will retain that power, means that they will keep that power after a conservator is appointed unless the court orders otherwise. There are times when you will always need to seek court permission to do things, for example, to move the conservatee to another state, to place the conservatee in a locked facility, or to isolate the conservatee from specific persons. Becoming a conservator is a serious undertaking. With that in mind, it is important to ask yourself if you are ready to become a conservator. Among other things, you will be arranging housing, attending doctor's visits, obtaining and arranging for medication, and evaluating and managing caretakers. Being a conservator can sometimes be time-consuming, so you should make sure that you're able to meet both your personal responsibilities and your responsibilities as a conservator. In some instances, the best course of action is to have more than one conservator so that the burden can be shared, and this is called having co-conservators. And the idea behind co-conservators is that you help each other complete the tasks that are necessary to take care of the conservatee. So before becoming a conservator, you should make sure that you will be able to handle the emotional component that comes with this job. You may have to deal with the proposed conservatee's lack of capacity, anger, rejection, and verbal abuse. You may also encounter disappointment when people who have promised to help you do not follow through. The court appreciates your interest in becoming a conservator, but it also encourages you to fully reflect on whether or not you'll be able to take on all the duties. You should continuously evaluate how being a conservator affects your life and ask yourself questions like, how will this affect me and my family? Do I have enough time and resources to be a conservator? If you hit a point where you feel overwhelmed, it is important to take action to either share the load or protect yourself. The public conservator is available in situations where there is no one willing or able to be a conservator. For more information, you can call the public conservator at 442-265-7000. Now we're going to talk about the conservatorship process itself. You are not required to have an attorney, but it is something you may want to consider. Although there are some local self-help resources, the assistance of an attorney can be beneficial, particularly when the conservatorship includes a conservatorship of the estate. Anyone can file a petition to become a conservator. An agency, a relative, or a non-relative may file a petition for appointment of a conservator, and there can be more than one conservator appointed. To start your case, you must file all the required forms in the Probate Juvenile Department, located at 939 West Main Street on the first floor of the courthouse. You will need to pay a filing fee or file an application for a fee waiver. The Access Center, which is in the lower level of the main courthouse at 939 West Main Street in El Centro, can provide you with legal information regarding the necessary forms and what they are used for. However, remember, the personnel at the Access Center are not attorneys, and they are not allowed to give legal advice regarding strategy or argument or tell you how to word what you place in the documents. You can obtain these forms, which are listed in the Handbook for Conservators, and these forms are the forms that you need to initiate the conservatorship process. And these are all online at www.courts.ca.gov. They are available in fillable PDF format. It is a legal requirement that they always be completed in English. You may petition for a temporary conservatorship in emergency situations. A temporary conservatorship may be set up when a person needs immediate help. A judge, upon finding of good cause, may appoint a temporary conservator of the person or of the estate, or of both, for a specific period until a permanent conservator can be appointed. A temporary conservator arranges for temporary care, protection, and protects the conservatee's property from loss or damage. In order to obtain a temporary conservatorship, the petitioner must show that there is an emergency or an urgent need for the appointment of a temporary conservator. Examples are the proposed conservatee needs surgery, or has wandered away or gotten lost, or money has been stolen and more is anticipated to be stolen before the general hearing. When you file for a temporary conservatorship, you must also file for a permanent conservatorship. You cannot file for only a temporary conservatorship. This is not an alternative to a permanent conservatorship. Notice and service requirements are similar to that of a permanent conservatorship, but notice must be given 5 days before the court date. The proposed conservatee must be served personally, and relatives are served by mail. While a permanent conservatorship continues until the conservatee dies or a judge officially ends it, a temporary conservator is appointed only for a fixed period, usually 30 to 60 days, and only until a permanent conservator is appointed or the petition for permanent appointment is denied. The letters of temporary conservatorship or temporary letters will show the exact date when the temporary conservatorship ends. A very important step within the conservatorship process is providing notice. This is one of the biggest challenges in the conservatorship petition process. If you do not follow the notice or service rules carefully, your hearing can be delayed, requiring you to return to court on a different date. The notice process is designed both to obtain the court's jurisdiction over the proposed conservatee and also to allow the conservatee or family members the opportunity to support or object to the petition. Therefore, you must arrange to have the proposed conservatee personally served with a copy of the petition and citation. You must also arrange to serve a copy of the petition and notice of hearing by mail to all proposed conservatees, relatives of the first and second degree. If you are the petitioner, someone other than yourself must give notice. Your server, the person who gives notice, will need to sign the proof of service and file the original proof of service with the courts before the hearing. All relatives in the first and second degree must be served. Relatives in the first degree are parents and children. Relatives in the second degree are brothers and sisters, grandparents, and grandchildren. If married, the proposed conservatee's spouse must also be served. The proposed conservatee must be personally served at least 15 days before the hearing. All other interested parties, including the proposed conservatee's family through the second degree, may be served by mail at least 15 days before the hearing. It is your responsibility to make sure the proof of service and the original notice of hearing are filed with the court. If after a diligent search you are unable to find one or more of the family members, you can ask the court to dispense with notice by filing a declaration or a diligent search. You must first conduct a reasonable search. Then you prepare the declaration to inform the court of your efforts to locate the whereabouts of this specific family member. If you know that a family member is in jail or prison, you must contact that facility and arrange for service of the paperwork on the individual. There are certain agencies that are entitled to notice. If the proposed conservatee is developmentally disabled, your server must provide notice to the regional center by mail 30 days before the hearing. This is true whether or not the proposed conservatee is a client of the regional center, as it is necessary for the regional center to meet the proposed conservatee, assess the proposed conservatee, and prepare a report to the court. Without this report, the court will not grant your petition. If the proposed conservatee is a patient in or on leave from a state hospital, the director of state hospitals must be served by mail at least 15 days before the hearing. Lastly, if the proposed conservatee receives or is entitled to receive veterans benefits from the VA, the Veterans Administration must be served 15 days before the hearing, and they are also served by mail. You can find more information about the San Diego Regional Center, which is the regional center for the Imperial County, at www.sdrc.org, as well as information on the other agencies who may be entitled to notice at the websites indicated on this slide. There are a few things that will occur before your hearing. Prior to a conservatorship being approved, the court investigator will personally visit and interview the proposed conservatee. The investigator in this county is the Imperial County Probation Department. The court investigator will also contact other parties, such as close relatives, possibly even neighbors and friends, to get an insight on the need for a conservatorship and as to the suitability of the petitioners. A written confidential report is then submitted to the court with the investigator's findings. Copies are then mailed to parties, as specified by law, including to yourself and your attorney if you have one. The investigative fee must be paid by the proposed conservatee or by his or her estate. The court may waive this fee if the proposed conservatee is a Social Security recipient or receives Medi-Cal benefits. In this county, the fee varies, and it ranges from about $75 to $150. When a petition is filed for a developmentally disabled adult, the regional center must assess the case and file a report with the court before the hearing. even if the proposed conservatee is not a current client. Therefore, as previously mentioned, it is important that you provide notice to the regional center. All conservators must complete this training and orientation pursuant to Local Rule 7.10. Probate Code Section 1457 requires the court provide a training for all non-professional conservators. If you fail to provide proof of completion of this educational program, the court may continue the hearing on the petition for a period long enough to allow you to complete the program, or deny the petition for appointment, or make other appropriate orders. The Probate Code requires mandatory appointment of counsel for the proposed conservatee if the petition is filed for a limited conservatorship or if the petitioner is requesting dementia powers. It is important to remember court-appointed counsel is the attorney for the proposed conservatee, not your attorney, and if there is a conflict, the court-appointed attorney will only represent the proposed conservatee and his or her best interests. Now we're going to discuss the hearing. Prior to the hearing, it is good practice to review the probate examiner's notes for your case. These notes do not contain any private or sensitive information, but rather are intended to show whether or not everything is in order. The notes include deficiencies and comments. The probate examiner's notes are available the Wednesday before your hearing on our court's website at www.imperial.courts.ca.gov. To prevent delays, you may want to correct any deficiencies noted by the examiner before the hearing, and if necessary, call the examiner at 760-482-2238. The examiner can explain deficiencies, but cannot tell you how or help you correct them. It is also good practice to keep conformed and endorsed copies of everything you file with the court. It is a good idea to bring your personal file to court with you. This is because sometimes the original document may not be in the court file at the time of the hearing. If you have your copy, you can show it to the judge to demonstrate that the original was actually filed. Please note, it is mandatory for the proposed conservatee to be present at the initial hearing unless he or she is excused by the court. When you first arrive to the courtroom, it is beneficial to let the bailiff know you are present. The bailiff is the deputy sheriff in uniform. Also, if you need an interpreter, advise the bailiff you need one and what language interpreter you will need. At the hearing, you should remember that the judge will call the case using the proposed conservatee's name. For example, if the proposed conservatee's name is Jane Doe, the judge will call the case as in the matter of Jane Doe. When you hear the proposed conservatee's name, you, the proposed conservatee, and any family or friends who are present will stand at the table before the judge. The judge will address everyone who is present, including anyone who disagrees with the conservatorship. If there are no objections, and if there are no deficiencies with your paperwork, the judge will likely make a decision regarding the petition by the end of the hearing. Now, after the appointment. After the appointment, there are some post-judgment forms that are required. If a limited conservatorship was granted, you will need to file Form GC 341, Notice of Conservatee's Rights. If a general conservatorship was granted, you will need to file Form GC 341, Notice of Conservatee's Rights, and Form GC 355, Determination of Conservatee's Appropriate Level of Care. The judge will likely give you a deadline by when these need to be filed. Pay attention to this deadline and also to whether or not you need to come back to court. After appointment, as conservator, you will be required to be present during some follow-up interviews. The first post-appointment interview will likely be at the first anniversary of the conservatorship being granted, but it can also be as soon as 6 months from appointment. The investigators will again come to the home or come to where the conservatee is located, will assess how the conservatorship is operating and if there is a continuing need for this legal arrangement. A report will be prepared and again mailed to the parties as set forth by the statute. Unless otherwise directed by the court, 2 years after the anniversary report, the conservatee again will be seen and interviewed in the same manner. The court investigator will prepare a report and file it with the court, with the exception that this time copies do not need to be mailed out to any of the parties. And this review process will continue throughout the existence of the conservatorship. As a conservator, you have certain responsibilities when it comes to changing the conservatee's residence. If the conservatee is moved from his or her residence, you must ensure that the conservatee continues to receive proper care, nutrition, and social interaction. As previously mentioned, the court approval is needed prior to moving the conservatee to certain facilities or out of state. In the event you obtain permission to move the conservatee out of state, a conservatorship or similar proceeding must be opened in the new state. When changing the conservatee's residence, as the conservator, you must give notice and inform the court. You must also give the court notice if you, as the conservator, move. It is very important that you do not forget to get court permission before moving the conservatee out of state. Different circumstances call for different procedures. You can always refer to your handbook for clarification as to what your responsibilities to the court are. Now we come to the end of a conservatorship. There are different ways a conservatorship may end. A conservatorship ends upon the death of the conservatee. When the conservatee passes away, you need to file Form GC 399, Notice of Conservatee's Death, and a death certificate with the court. The conservatorship may also end upon court order. When a conservatorship ends upon court order, there likely was a comprehensive investigation completed, and it was determined by the court that ending the conservatorship was in the best interest of the conservatee. An example of this is when a younger person suffered an injury which necessitated the conservatorship, but ultimately healed to the point where this is no longer necessary. So upon petition, the court can terminate the conservatorship. The court may terminate your status as a conservator. That does not necessarily mean the conservatorship itself has terminated, but your status as conservator may be terminated upon death, resignation, or removal by the court for failing to act in the best interest of the conservatee. As previously mentioned, you may be removed as a conservator. The grounds for removal include, but are not limited to, negligence, felony conviction, abandonment of the conservatee, or any other reason the court deems would be in the best interest of the conservatee. The court appreciates your willingness to assist the conservatee and understands the personal sacrifices that are involved in the effort. We remind you that ongoing self-assessment is appropriate to make sure that you are fully up to performing the duties you are undertaking, and if there is a problem, you should not hesitate to reach out for assistance.